missed a crap ton of questions. You missed 30. Okay, you got to score a 70 to pass. Now, you get extra credit questions. There are 2. Each of them is 1 point. Okay? So, again, now, a couple of things. I'm not going to get a chance to announce this before you take your exams because people will be trickling in, you know, between 5 and 6. So, when you answer your question, I'm going to give you, you're going to get a booklet with the questions, okay? And you can circle your answers right on the test, okay? I'm not going to give you a little, you know, answer thing that you have to shade in the one. You can just answer on the test. If you're inclined to change your answer, then make sure I understand which one doesn't count anymore and which one is the one you want, okay? Because if you circle 2 and one's right and one's wrong, I'm going to mark it wrong, okay? You circle all 4 and you're like, I ain't got one of them. That's not going to work, okay? So you got to make it clear what your choice is. I'm not saying do not change your answer, but I'm going to tell you 9 times out of 10, the one you picked is your instinct, your first instinct is the correct one usually. Let's see, answer all of the questions. What happens, because in an effort to conserve paper, the question is, the test is front and back. And sometimes people don't flip and answer the questions on the opposite page. So they get most of the questions, you know, like 50 of them, and forget to answer 50 of them. And that's rare. That happened one time, but there is an instance where you miss a whole page because you just forgot to flip the other side. The good news is if you wait for me to answer or wait for me to grade it, I'm going to say, hey, you missed an entire page of questions, here you go. But if you leave, I'm not calling you to say come back, okay? I'm just going to mark all those wrong. So make sure you answer all the questions, okay? What's the answer to question 49? Okay. Not everybody's sure about that. What's the answer to question 49? Okay. There will be at least 1, if not more. The world record was a Keller Williams class, and 5 people missed question 49. So, now what happens when you miss question 49? I will bring each and every one of you who missed it to the front of the class, and we will all laugh at you. No, I will not do that. It's some weird sociology kind of experience. I don't know what it means, but there's for whatever reason people aren't getting question 49 right when you have actually been giving the answer. I think I said this. There was a guy who got all the questions right, including the extra credit, and the only one he missed was 49. And he outed himself, actually, in class, saying, you know, I'm a complete dumbass, I missed 49. I got everything else right. Okay, what else I got to tell you? You can leave as soon as you're done. If you want to wait around for your grade, that's fine. If you zoom through it like the one guy and get done in 15 minutes and take off, you're done for the day, okay? So, before, I just make sure it's signed up for Wednesday, because that happens or something. All right, so we look good for Wednesday starting early. All right. Okay, so is everybody ready now to jump into this?
Yes.
Okay. All right. This is going to kind of jump around a little bit, so just sort of bear with me. I will try to tell you what unit we're talking about with a particular, question and the material. So I will try to sort of say, in unit, this is what we looked at. Okay. So Unit 2, that was the first unit we really looked at. And in Unit 2, we talked about the physical characteristics of real property, and those physical characteristics were immobility was one of those. So the geographic location of a parcel relative to other parcels doesn't change. Another physical characteristic was indestructibility. And the last physical characteristic was uniqueness. Now, we also talked about personal property, and the big characteristic between personal property and real property was mobility. Personal property is movable, and real property is not. Again, the geographic location of parcels doesn't change relative to the other parcels. So mobility is that biggest distinguishing characteristic between real property versus personal property. In Unit 2, we also talked about certain things that are considered real property and certain things that are not. So those man-made improvements that are added to the property, like sewers and buildings and roads, those things are all part of the real property. Those things, those man-made improvements, become part of the real property. Then we talked about certain plants. Some plants are considered real property and some plants aren't. So fruits of nature, those things that are naturally occurring like trees and grasses and those kinds of things, those are all considered part of the real property. Fruits of industry, crops, what they sometimes refer to as emblements, those things that require annual cultivation are considered personal property, and crops is a really great example of a fruits of industry that is considered just personal property. Okay, we're doing okay with the pace?
Yes.
Okay. All right, something that happens from time to time in my practice is, and it's usually what sounds to be like an elderly lady, and she's looking out her back window, and Delmarva Power is got some sort of truck in her backyard, and some guy in a bucket cutting away the limbs off of the lines there. So some utility companies on her property cutting back trees off of lines, tree limbs, and she's really upset. Like, they're trespassing. It's her property. How in the heck can they be on my property? Okay, so invariably, while I'm chatting with her on the phone, I have the ability to bring up stuff on the recorder of deeds and look and see if there's any easements against her property. And lo and behold, in her deed it says it's subject to a utility easement in favor of Delmarva Power. So I'm like, well, man, there is a utility easement of record against the property, and so they do have a right to maintain their the easement that they have, which is to cut back tree limbs off of these power lines. So they do have a right to be there. So usually the response is, well, I didn't know about it. Well, remember, when you record something like an easement, there's constructive notice of it. So whether she knows about it or not, it's valid. Now, we're then talking about an easement, right? So when we're talking about a utility easement, what kind of easement is that? Is it a pertinent easement, or is it an easement in gross?
Gross.
It's an easement in gross, because you've got a benefited entity and burdened properties. With an appurtenant easement, you've got a benefited property and a burdened property. Okay? So let's sort of stay on the easement subject here. When you're given easement questions, first try to figure out, are we talking about a utility easement? And if we are, that's an easement in gross, and it's not an appurtenant easement. The next thing is, okay, we know it's not a utility easement, so it's not an easement in gross. So it's an appurtenant easement. An appurtenant easement question might be, the Hatfields grant to the McCoys the right to cross the Hatfields property. So what I would do is I would just draw two parcels side by side, label one H, label one M, Hatfields and McCoys. The fact pattern says the Hatfields have given the McCoys the right to cross the Hatfields property. So you would draw a little easement over the Hatfields property, and then you could look and say, okay, the Hatfields property is the burdened property. The McCoys have the right to cross the Hatfields property, so they're the benefited parcel. So then you'd answer the question. So the McCoys property is the dominant tenement. The Hatfields property is the servient tenement. Okay? The burdened property is the servient tenement. The benefited parcel is the dominant tenement. And it's a appurtenant easement. Okay? Two parcels. Okay, the other thing about easements is those rights, the burdens and benefits that come with an easement, they run with the land. That's a phrase that means successive purchasers take subject to either the burdens, if they're purchasing the servient tenement, or successive purchasers take the benefits if they're purchasing the dominant tenement. Okay, everybody get that? Makes sense? Get that, Carolyn? All right. All right. Now, don't do this, please. You were told there's 100 questions. Somebody once, when I was doing a review, they ticked off each thing that I had talked about, and they got to 100, and they said, "Why aren't you done?" And I'm like, "No." And she's like, "Well, you talked about 100 different things right now." And I'm like, "Oh, yeah, but some questions have more than 2 ideas in them. So we're actually not even close to being done. So please don't do that." Okay.
Do you take any of your questions from the book?
No.
None?
None.
So, but would it still behoove us to do those practice quizzes again?
To be honest with you, I have never looked at those questions. I don't know how close they align with the way I ask questions.
Okay.
I mean, they're multiple choice questions. I think they're probably helpful to look at. My advice is to kind of just listen to this review. It's being taped. Did I click that thing?
I did.
Okay. And maybe listen to it a couple of times. Study those areas that I've told you in the study guide. Oh, I meant to tell you this. In the study guide, what I have there is things that you need to look at in Larry's materials. I'm not going to ask you a whole lot of stuff about the Licensing Act, and what I'm going to ask you, I'm going to give to you in the review. So don't go read 100 pages, or not 100, it's 50 pages. Don't read the 50 pages in that book for purposes of studying my exam.
Okay.
When you're studying for the state exam, you got to read that. Read those 50 pages. The other thing that I had suggested was looking at the Delaware Landlord Tenant Code in Larry's materials, that summary of the code. Don't look at that. I'm going to give you the limited stuff you need to know, and they're extremely limited. I don't want you, wasting your time reading things you don't need to look at. But the study guide references to modern real estate practice. You look at it and you're like, oh, that's a lot. But if you actually look at it, it's like a page here, a page and a half here, maybe as much as 3 pages. It really isn't a lot. So for purposes of studying material for my final exam, don't bother looking at Larry's supplemental materials. You look at that when you're doing the state exam after my final, but not before. Okay. All right. Okay. Okay. I gave you guys a grid sheet where it's showing you all the forms of co-ownership and then different categories for each. That looking at that document is going to help you deal with questions. Now, so let's say I've got a question where I say two people co-own something and they're not married. And I say one dies. And then the fact pattern goes on to say the other co-owner now owns the whole property in just his name. What form of co-ownership is that most likely?
Joint tenancy.
That is joint tenancy, because it has that right of survivorship. He survived to take the other co-owner's interest, so that survivorship means he takes that. If the fact pattern was in the reverse and it said there are 2 people, they co-own it and they're not married, and one dies and the other co-owner's interest does not change, it does not increase, it stays the same, what form of co-ownership is that most likely? And that would be tenants in common, because if he succeeded to the whole, there was a right of survivorship. His interest doesn't change, which means there wasn't a right of survivorship, so it would be tenants in common. All right, let's stay on that topic for a little bit. So with tenants in common, it does have certain similarities with joint tenancy. One of them is it can be 2 or more. It's not just limited to 2. Tenants in common, there could be 100 people. co-owning property as tenants in common. Same thing with joint tenants. The other things that are in common with tenants in common and joint tenancy is this right of partition. Each co-owner, be it tenants in common or joint tenancy, has the right to go to court and have the court split the property up in accordance with the party's interests. They'll usually do that by sale. Okay? Each co-tenant, be it tenants in common or joint tenancy, has the right to convey their interest without the consent of the other co-owners. Now, here's where they differ. Joint tenancy has a right of survivorship. That means that when one co-owner dies, the other one will take his interest. And that's an absolute right that can't be defeated by a will. It can't be defeated by any way that someone could take property by virtue of being an heir. If you die, by operation of law, your property will go to the other surviving co-owners. With tenants in common, there is not a right of survivorship. There's no right of survivorship. So when one party dies in a co-tenancy, then their interest will pass to their heirs, either under a will or, if no will, under the law of intestate succession for that particular state. And remember, that's just a law that presumes your intent if you don't have a will. The law says, we're going to deem your property to go to your closest living blood relatives. Then the other thing that differs is the presumption category. If a deed is silent about, and they're not married, and the deed does not specify the form of co-ownership, then the presumption's in favor of tenants in common. So if you got a fact pattern where the co-owners weren't married, and it says the form of co-ownership was not specified in the deed, I've told you tenants in common. That's the presumption. There is no presumption in favor of joint tenancy with this right of survivorship because of the right of survivorship. Courts say, look, if you want that right, you better spell it out in the deed. And if you don't, we're going to deem it tenants in common. Okay? Does everybody understand the presumption part there? Oh, great. Tenants by the entireties is the form of co-ownership where only married couples can own it that way. Number one, there is a presumption in favor of it. What does that mean again? It means that if the deeds, if the fact pattern says that property is conveyed to a husband and wife, and I don't tell you the form of co-ownership, yes, I have, because the presumption is tenants by the entireties. So if the deed is silent, so Roger Granson conveys unto Bill and Ann, who are married at the time of conveyance, and again, the deed is silent, then the form of co-ownership will be deemed tenants by the entireties. Okay? Bill and Ann get divorced. Since they're no longer married, tenants by the entireties will get automatically converted upon divorce to tenants in common. No new deed is done. The fact of them being divorced is what changes that form of co-ownership to tenants in common. For instance, the beach house I own with my ex-wife, my deed says Roger and Stacy, husband and wife, as tenants by the entireties. We're divorced. Hallelujah. That means I co-own it with her as tenants in common. Now, with tenants by the entireties, there is a right of survivorship. So if one spouse passes, by operation of law, the other one becomes the owner of the property. So there is a right of survivorship. With tenants by the entireties, there is no right of partition now. So if the parties, if husband says I want out and wife's like I'm not going to let you off the title, then they'll probably end up in divorce court to try to get that handled because there is no right of partition. And neither spouse can convey their interest without the consent of the other. Okay? So that's, in a nutshell, all you need to know about co-ownership. And that little cheat sheet that I gave you, that one-page sheet, that I think is a great resource to look at. Okay. in Unit 13, we talked about real estate taxes and other liens. And one of the liens that we talked about was the mechanics lien. So the main thing that I want you to know about a mechanics lien is that it's only available to someone who supplies labor or materials for the benefit of a structure. So it could be Home Depot delivering on credit wood to frame out a house. So when they come and deliver it to the property and they don't get paid, they could file a mechanics lien to get paid. The framers who take that material and now frame the house, if they don't get paid, they provided labor for the benefit of a structure, so they can file a mechanics lien. Only people who supply labor and materials can file a mechanics lien. If you are a real estate agent, you get stiffed in the transaction, you didn't hammer nails, you didn't bring materials, you're not entitled to file a mechanics lien because you did not do some level of construction, repair, or maintenance, or supply materials for that, okay?
Can you give us an example of how you word one of your questions, even if it's 49, which we already know, if you don't want to? I mean, is it pretty similar to how the book is worded?
I don't know how the book is worded,
Oh,
but
okay.
there's nothing tricky.
Okay.
To the extent there are tricks, I'm going to tell you, here's the trick. I give it away. Give it all away.
Okay.
So Dave has no part in this at all.
To the extent that I had a tinge of Dave running through my veins when I crafted a question, I tell you, here, don't get tripped up by this particular thing. Okay, I'll give away the trick.
All right,
Okay.
thank you. Thank you.
All right. Okay, in the contracts unit, which was unit 12, we talked about some remedies that a buyer has. And one of the remedies a buyer has when a seller refuses to sell him the property that he has agreed to sell under the agreement of sale is a remedy called specific performance. You don't get that remedy unless the property that's being sold is unique. And real estate, we know, by definition, physical characteristic is uniqueness. No two parcels are deemed the same. So when the seller says, you know what, I actually don't want to sell you this, the buyer can sue the seller for specific performance. What is he looking for? He's looking for a court order ordering that the property be sold or conveyed to the buyer. Specific performance. If you just think about it, you're asking to specifically enforce the agreement. And enforcing the agreement against the seller is compelling him to convey the property to you. You know, it's odd. I've been chatting for nearly 30 minutes and I haven't used the word shit once. So it's amazing. Hi. So now you officially can't play this around your children. Okay? All right. Okay, the earnest money deposit. We know that's the money that the buyer puts up when he makes his offer under an agreement of sale. It's the money that he is agreeing to have held in deposit against the purchase price. It's called earnest money because the buyer, in a sense, is showing that he's eager to move forward. I'm earnest, you know, I'm ready to go. And I'm so ready to go, I'm actually going to give you some of this purchase price up front with this deposit. Now, who determines what that earnest money deposit is? Is it the real estate commission has some set schedule?
No.
Is it your broker organization that says this is what it has to be? Or is it something the parties negotiate?
Parties negotiate.
It's something the parties negotiate. All right, so she's going to zoom in on this, get the frickin' answer to the question. You got to watch out for that Cepeda lady. All right. Now, when we were doing the contracts unit, we talked about this law called the statute of frauds. And the statute of frauds says that certain documents, in order for them to be enforceable, must be in writing. So one of those was an agreement of sale involving real estate, where the parties have agreed to purchase and sell real estate. That agreement has to be in writing, and that law is called the statute of frauds. In the contracts unit, we did talk about something called an option. And an option is really where you have given someone the right to purchase your property at a set price for a definite set period of time. So an option might be you, Donna, you have the right to purchase my property for $100,000 for 5 years starting from today's date. So it's got to be a definite set price and a definite period of time to exercise the option. Now, I'm not going to, just as an aside, there's a law and a principle called the rule against perpetuities. If I gave Donna an option to purchase my property for $100,000 and I didn't set a time frame, that option is no good because it violates the rule against perpetuities. It never vests. It can go on forever and ever. In other words, I could own it and I can die and my heirs take over the property. They'll take subject to the option that Donna has, and theoretically that interest in real estate never vests. The rule against perpetuity says you can't have that. The interest has to vest at some point in time. So that's why it's got to be a definite time. Why I told you that, I have no idea. Because my brain is filled with lots of silly, stupid information. That's why.
So forget about perpetuity.
Yes,
right?
forget about it.
All right.
Strike that from your
Got
brains.
it.
And never utter that again. And if I catch you saying rule against perpetuities, I don't know what I'll do.
You won't catch us.
I'll kick you in your butt.
It's all good.
I told you not to say that. Okay. All right. Escheat. So in Unit 4, we were talking about governmental powers, and one of those powers was escheat. And when we're talking about real property, when you die and have no heirs, no blood relatives, nothing, when your bloodline is gone, then your property reverts back to the state. And that power is called escheat. E-S-C-H-E-A-T. Escheat. Okay. We record a document primarily because of what the state law gives you. So recording is a creature of state law. And when you record what you're looking for, because if the state law doesn't give you this, then why would you record? Number one, it gives you constructive notice of your interests. That means that by simply putting it in the public records, people are deemed to know of your interest. Whether they know about it or not, they're deemed to know. Much like that old lady who is not aware that she's got this easement in gross, this utility easement that affects her property that allows Delmarva to come on and cut back the limbs from the power lines. It seems like it's the never-ending thing they do in the Pike Creek area. Like, Bert knows what I'm talking about. They're constantly cutting limbs away from the power lines, and anytime the wind gets above 5 miles an hour, power goes out somewhere in Pike Creek. It's just nuts. So, anyway. And again, I've made a left turn. Okay, so the next thing is that gives you priority. So constructive notice and priority. And priority is really the ordering of your interests. And the basic rule of priority is first in time, first in right. Whoever records first has first priority. So the date and time a document is recorded establishes its priority. You can't simultaneously record documents, although I guess you could if you bring them to two separate windows. You're like, hey, let's see if we can record something exactly the same time, but that's kind of rare and difficult. But again, the date and time that something's recorded establishes priority. And that's Unit 8. Unit 14, we talked about real estate financing principles. And in Unit 14, we talk about interest. Interest is what the lender charges you for use of their money. And state laws have typically what's called a usury law. U-S-U-R-Y, usury. Usury is charging more than what's legally allowed. Okay, in that unit, Unit 14, Real Estate Financing Principles. We talked about who the mortgagor and who the mortgagee is. So the mortgagor is who?
Borrower.
The mortgagor is the borrower. He borrows the mortgage funds. The mortgagee is the lender. Now, believe me, when I draft mortgages, I always have to pause and like, who the hell's the mortgagee? Who's the mortgagor? And literally this goes into my brain. Mortgagee, money, who's got the money? The bank. Okay, the bank is the mortgagee. That's what goes into my brain, as silly as that sounds, and now it's been on tape, it'll make it on YouTube, and hallelujah.
Maybe two E's in mortgagee and in lender?
Well,
Okay, maybe.
Maybe.
also mortgagor and borrower are both OR.
That's
Yeah,
true,
there
too.
we go.
However that helps you remember, so we've got
There we
some
go.
points.
That's the way I have it in my brain.
Now, I would say knowing mortgagor and mortgagee is a Dave thing. But because it's a Dave thing, let's at least start looking at questions that have that so you get familiar with the terminology. It would be easy for me to use borrower and lender. But since since Dave's never going to use it, and probably the national exam part's not going to use it either, let's start looking at test questions that use mortgagor and mortgagee, okay? All right. Now, this happens a lot in my practice. You pay off your mortgage. Let's say that you refinanced your first mortgage with a new mortgage, and you paid off the first mortgage. And now you're selling your house. And the buyer's attorney calls you and says, we're going to need payoff information from your WSFS mortgage from '07 and payoff information for your M&T mortgage that you got in 2016. You're like, the 2016 mortgage paid off the 2007 WSFS mortgage. I paid off that mortgage with a refinance. Oh, well, guess what? The lender did not remove the lien. It stays a lien until the lender records a satisfaction of mortgage. So to remove the mortgage, you got to record a satisfaction of mortgage. Otherwise, it stays a lien. Okay? All right, still talking about the financing unit. Okay? And now we're talking about foreclosure. When a lender forecloses, 99 times out of 100, the lender does not get enough proceeds to cover the balance of the mortgage. So the high bidder, which may be him, or the high bidder, which may be somebody else, doesn't bid enough to cover what he's actually owed. So the mortgage now has been foreclosed upon, and the lender cannot milk anything more out of the property. It's been foreclosed upon, the mortgage is now gone. So the remaining document is the note, the promise to pay back the loan. So if the mortgage doesn't yield enough proceeds to pay off the balance of the mortgage, if that foreclosure doesn't, then the lender can then pursue against the borrower, the mortgagor, a deficiency judgment under the note. He can sue you personally and say, okay, I got $100,000 in proceeds from the foreclosure sale. I was owed $120,000. You're $20,000 short, so I'm going to seek a deficiency judgment under the note for 20 grand. So again, when you do a loan, a mortgage loan, there are two primary documents. There's a mortgage and a note. The mortgage is nothing more than pledging the property as security for the loan. So if you don't pay back the loan, the lender can use the mortgage to go after the property and force it to be sold in a foreclosure sale, a sheriff's sale. You still got a promissory note, which is where you promised to pay back the loan. And so he can pursue you under that if he doesn't get enough to pay off the proceeds. Again, that's called a deficiency judgment. Okay, now if I asked you a question, and I will on the final exam, of the two documents in a mortgage loan, which is the evidence of the debt, the mortgage or the note?
Mortgage.
And the answer is note.
The note.
Oh, I'm sorry. Well,
Okay.
know that answer.
Now, think about the note, and think, those of you who have mortgages, what are the loan terms? Where are they? They're not in the mortgage.
No, they're in the note.
They're in the note. The note says you promised to pay me this money. You promise to pay me $100,000 at 3.875% interest. Your first payment starts June 1, and the maturity date is May 31, 2047. So it's a 30-year loan, right? So all the terms of the loan are in the note. The note creates the obligation. It creates the debt. That's why it's the evidence of the debt. So in order to pledge property as security for a loan, you got to have a loan. The note is the loan. The mortgage is not the loan. The mortgage is where you're pledging property as security for a loan. You got to create the loan first and then pledge it as security. So you got to have underlying debt before the mortgage works. The mortgage is meaningless if there's no debt, and the note creates the debt. It creates the obligation to pay back money. That's debt, okay? I got a wallet full of debt. They're called credit cards. Friggin' 24% credit cards. Thank you, ex-wife. All right. I feel better. I'm not bitter. Okay. Acceleration clause. That's the clause in the mortgage that allows the lender to declare the balance of the loan immediately due and payable upon default.
What unit is that in still?
Unit 14.
Thank you.
Allows the lender to,
Declare the entire balance immediately due and payable upon default.
What is that, satisfaction of
No,
Acceleration
that's
clause.
acceleration
the
clause.
Celebration.
It allows, it's the lender accelerating the balance. It's the balance being declared due and payable upon default. That makes sense, right?
It's full right now.
Okay.
Because you need to have that.
If you don't have an acceleration clause, the mortgage doesn't mean anything. Because you can't, if they can't accelerate the balance and declare it immediately due and payable, when they foreclose, they can only foreclose on the payments that you missed, not the future payments. In order for them to be able to collect the future payments, they have to accelerate them. And they accelerate them when you're in default. Oops, you're late on your payment. Okay, now the entire 100 grand is due. You're like, what? Now, most mortgages, there's a notice requirement that they give you 30 days notice. Hey, you're 2 months behind, you got 30 days to get caught up. Then if you don't get caught up, that's when they accelerate the balance, okay? All right, in unit 12 of all things, it was the contracts unit, but they talked about actually owner financing. And this was towards the tail end of that unit. And owner financing, the real purest owner financing is what's called a purchase money mortgage. It's literally the seller providing you the loan. Now, sometimes people have a hard time wrapping their brain around that. They're like, okay, so the seller's getting a loan, so the seller's going to a lender to get money to give to the, no. The seller is the lender. So let's say the buyer has no money, and the seller knows that. And he's gonna sell him the property, but he wants him to pay back the purchase price over time. So he could do a purchase money mortgage. So I'm gonna deed you the property. You're gonna sign a promissory note promising to pay me back $100,000 over 10 years. And then you're going to sign a mortgage in favor of me, pledging that property as security for the $100,000 you're promising to pay back me. The seller's not giving $100,000 to the buyer. He's owed $100,000 because that's the purchase price. So hey, I'll promise to pay you that purchase price at 3.875% interest over 10 years. And then the seller says, I just deeded you that property. You're now going to sign a mortgage pledging that property as security for the loan I just gave you. Everybody get that?
Yeah.
That's called a purchase money mortgage. It's where the seller extends credit to the buyer. Purchase money mortgage. Okay. You may have wondered when we were talking about co-ownership, perhaps, like, okay, tenants in common, joint tenancy, and tenants by the entireties. Boy, that sounds like a lot of leases, doesn't it? But a tenancy is nothing more than a right of possession. And so when you're talking about tenants in common and joint tenants and tenants by the entireties, you're talking about co-owners that have rights of possession. And so tenant is not exclusive to leasehold interests and leases. So if you're given a list of different kinds of leases and different kinds of co-ownership tenancies, be able to figure out which one involves a landlord-tenant relationship and which one is not a landlord-tenant relationship. So for instance, is tenants in common a landlord-tenant relationship? No, it's co-ownership. Is periodic tenancy a leasehold, lessee-lessor relationship? Periodic tenancy. That's like
Yes.
the first one we talked about.
Yes.
Yes, it's a kind of lease. So here's what I'd like you to know. Go back to Unit 18 and look at the different, there's basically 4 different kinds of tenancies for leases. A tenancy at will, a periodic tenancy, tenancy from year to year, and a tenancy at sufferance. Those were the 4, okay? Unit 18, the leasing unit. Okay, now, back to the ors and es talking about leases. The lessee is who? The landlord or the tenant? The lessee is the tenant. The lessor, obviously, is the landlord, right?
Yes.
Okay. Now, in Unit 2, we talked about fixtures. And if something is a fixture, it's going to be deemed part of the real property, correct? But we had this exception to fixtures, which was trade fixtures. Trade fixtures is the property of a tenant in a commercial lease. And so it remains the property of the tenant so long as he removes them prior to the end of the term. If his trade fixture remains after the term, then the trade fixture is the landlord's property, the lessor's property. So if they're removed before the end of the term, they're the lessee's property. If they remain after the term, it is the lessor's property, the landlord. Okay. I own a house on Union Street. And in 1950, I turned it into a Casapula's sub shop. And then in 1954, the city of Wilmington adopts a zoning code and sticks me in the R1 zoning district, which doesn't allow for sub shops. Am I still allowed to be a sub shop, and why?
Yes.
And the better word for grandfathered is non-conforming use. You are allowed to continue your sub shop because you are a non-conforming use. Okay? All right. Real estate transaction. Seller has paid the property taxes past the settlement date. He will get reimbursed the property taxes paid past the settlement date in a process called what? Prorations. And it will show on the settlement statement as a credit to the seller and a debit to the buyer. So if the taxes are prepaid past the settlement date, they will be adjusted amongst the buyer and seller in what's called proration, and that proration will result in a credit to the seller and a debit to the buyer. Okay? All right. If I die with a will, that's called testate. So I die testate if I have a will. If I die without leaving a will, then I die intestate. So intestate, no will, testate, will. That's Unit 7. Conveyance of decedent's property, pages 111 through 114. Okay. All right. So, my beach property, I own with my ex-wife. The deed is titled tenants by the entireties. We are divorced. What form of co-ownership has it been converted to? Tenants in common. Delaware is a lien theory state. A lien theory in terms of mortgages, okay? What does that mean? That it grants to the lender, the mortgagee, a lien on the property. That's all it does. We are not a title theory state, which is like Maryland or Virginia. We are a lien theory state, so the mortgage is nothing more than granting to the mortgagee a lien on the property.